The next bill on the calendar for the day is House File 1913. The clerk will report the bill.
House File number 1913, number 3 on the calendar for the day, an act relating to insurance, the first engrossment.
There is an amendment at the desk. The clerk will report the amendment.
Elkins moves to amend House File number 1913, the first engrossment. The amendment is coded A3.
Representative Elkins.
Thank you, Madam Chair. The A3 amendment merely adds a data retention provision to the bill. It should go without saying that if you had a data breach, that you should retain the data. This makes it explicit.
Any discussion to the Elkins amendment? Seeing none, all those in favor, please say aye. Aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File number 1913, as amended.
Third reading as amended. Representative Elkins.
Thank you, Madam Chair. The National Association of Insurance Commissioners is the U.S. standard-setting and regulatory support organization created and governed by the chief insurance regulators from around the country. Although through the NAIC, state insurance regulators establish standards and best practices, conduct peer review, and coordinate the regulatory oversight. This process helps states adopt more uniform regulations and across the U.S. and also enables Minnesota-based insurance companies to do business in other states without having to seek certification in every individual state that they do business in. This bill addresses several high-profile data breaches of insurers and other financial institutions, which prompted NAIC to develop this Model Act to protect consumer information. The U.S. Treasury is recommending states adopt this model legislation to ensure insurance companies can address cybersecurity threats. This bill establishes data security standards for both regulators and insurers to help mitigate the potential damage of a data breach. This proposal requires insurers with 25 or more employees to prepare a plan to address data breaches, properly investigate cybersecurity events, and notify the Departments of Commerce or Health within 72 hours of a cybersecurity event that involves 250 or more Minnesotans, and also notify consumers if their information was compromised. 8 states have already adopted this model statute.
The member from Anoka, Representative Scott.
Thank you, Madam Chair, or Madam Speaker. I'm wondering if the bill's author would yield to a quick question.
He will yield. Representative Scott.
Thank you, Madam Speaker and Representative Elkins. My question is on page 10 of the bill, line 10.27 and following. And it talks about consumer notification not being required if the event is resulting from a good faith acquisition of non-public information. And my concern there is I go back to a situation that was state related, but it was when MNsure was being ramped up, and several people's social security numbers and names associated with those were wrongfully breached out to some insurance providers, some agencies. And even though maybe at the time, so in a private sector situation, even though at the time there was no nefarious activity going on and that information was acquired, there's nothing to say to me that people should still be notified that their information was breached, simply because maybe at the time those employees, they don't do anything immediately on that breach data, but maybe they save that, and a year from now, they use that information to steal someone's identity. And to me, there ought to be some way of following up on that, so that in my opinion, I guess the consumer should know. The consumer should be notified regardless, because even if no immediate nefarious activity takes place, it could take place down the road. And if you don't have record of it, you may never know who the guilty person is. Do you follow me, Representative Elkins?
Representative Elkins.
Representative Scott, yes, I think I'm following you. So basically, the provision you're talking about says consumer notification is not required for a cybersecurity event resulting from the good faith acquisition of non-public information by an employee or agent of the licensee for the purposes of the licensee's business, provided the non-public information is not used for a purpose other than the licensee's business or subject to further unauthorized disclosure. I'm not sure that the MNsure example would really be relevant. This is dealing strictly with commercial breaches, and I think this is. I think that the exception that's made here is in cases where there really isn't any real harm of risk of any harm coming to a consumer from an inadvertent internal disclosure of information to an employee who is actually working with the data and needs it to conduct their work.
Representative Scott.
Thank you, Madam Speaker. I'm not sure that I interpret it the same way, but I do have concerns about that section. And I don't know, I'm just of the opinion that anytime someone's data doesn't go where it was supposed to go, that the person should be notified. And I know that probably that would be a lot of notifications, but there has to be some way of tracing it back to an origin if something down the road happens with that data and a person's data is used for, identity theft or whatever. And I feel like this leaves the door open for that to happen. I'm still going to support the bill, but I have concerns over that section as I read it in its practical, in its black and white language.
The member from Wright, Representative Lucero.
Thank you, Madam Speaker. And would the bill author yield for a series of questions?
He will yield. Representative Lucero.
Thank you, Madam Speaker. And I'll just start with where Representative Scott left off. And that particular scenario with the MNsure, I think it was 2013, 2014, around that time frame. And what happened there is that it was an email list, if I remember correctly. A list was emailed out by an internal employee to an external party, and it was not encrypted. And that information included PII, first name, last name, social security number, street address, things like that. And one of the things that I was just on a warpath at the time, and I still am, is here we have a brand new information system with the latest technology being implemented, and they can't even stop an email breach from data being sent out when the technology to detect and to encrypt such emails, either to stop or encrypt such emails, had been around for a decade and a half by that point, and they couldn't even do that. And so it was amazing, the royal flop there. But I do see here, and this is not one of the items that I picked up in my reading of the bill, so I appreciate Representative Scott bringing this to our attention, because I do see that. A good faith acquisition, well, that would have been an example of a good faith, right? So in good faith, the employee sent an email with an Excel or some other attachment that included PII, that the email itself was not encrypted. It was sent out in an unencrypted method, and therefore that is a data breach. And so the fact that it was done in good faith, it doesn't excuse or lessen the potential impact, but I'll leave that where it is. And just to be upfront, Madam Speaker and Representative Elkins, I appreciate your efforts in this, but I am not a member of the Civil Law Committee, the Judiciary Committee this term. I have been in the past. So I did not have the opportunity to review this with you in detail in the committees that I'm on. The only time I saw this was in Commerce, but it was a very narrow jurisdiction of which we were reviewing the language. So I appreciate your efforts. I think at the time I expressed then, and I'll express now, I am very skeptical when it comes to model language. In my 7 years here at the legislature, model language is very necessary, but it introduces a lot of redundancy, and it can unintentionally exclude a lot of stuff that should be included. And in my reviewing here, I see many examples of that. So I'm actually not going to vote for this bill, but the questions I'm about to ask you are not gotcha questions. They're just I'm just trying to understand the model language that was taken and translated then obviously into Minnesota statutes. So Madam Speaker and Representative Elkins, the first question I would have for you is, and I've highlights all the way down here throughout the bill. And so just in no particular order other than the order of which they appear in the lines in the bill. On line 1.16, you define a cybersecurity event. Well, the common nomenclature in cybersecurity, as you're aware as a technologist, database administrator, I believe, yourself, you're aware that the common nomenclature is event versus incident. And so here we have the first example of model language, in my opinion, not the best of use that it could be. And so I think that we should define this as an incident, because that makes it very clear and lines up with the standard nomenclature in the field. But then when you read down the line, the definition of what a cybersecurity event is, and it means an event resulting in unauthorized access to or disruption or misuse of an information system or non-public information stored on an information system. Well, what about non-digital access, Representative Elkins? In this bill here, is there information that in all other aspects would be in scope, except for if it's not digital, if it's a printed copy, like a printout, or if it's on somebody's screen, faxes, pictures to that effect, so tangible evidence or information, I should say, that's not digital. Would that be in scope of this language here?
Representative Elkins.
So thank you, Madam Chair, Representative Lucero. So I think one thing to keep in mind with legislation of this nature is that insurance companies operate in two dimensions. They're insurance companies, but typically they're also either healthcare companies offering health insurance or financial services companies, also subject to federal regulation under Graham-Leach-Bliley. And I think you need to look at the total, the web of security legislation that these companies can be subject to. So in the example, let's go back to the MNsure example for a second. A breach in MNsure wouldn't be covered under this because it's data in government's hands and it would be governed by the Minnesota Data Practices Act. If a breach of information related to health information would be subject to both this bill and HIPAA. And the example that you cited would be a violation under HIPAA and would have to be reported under HIPAA. The same thing with a financial company offering life insurance or annuities. If there was a breach there, they would be subject to both this act and to the federal requirements under Graham-Leach-Bliley. So the answer basically is no, that this bill isn't going to cover every single situation that any insurance company in any vertical would face, but it covers things that would be applicable to any insurance company as an insurance company.
Representative Lucero.
Thank you, Madam Speaker. And would the bill author yield for another question?
He will yield. Representative Lucero.
Okay, thank you, Madam Speaker. And Representative Elkins, so you're saying there is redundancy here, and you're absolutely right. Having worked for an insurance company, medical insurance company in the past, yes, they're absolutely subject to regulatory requirements, HIPAA and high-tech. I worked for a medical device manufacturer in the past, and that was obviously the same thing, subject to HIPAA and high-tech. Financial institutions, yes, Graham-Leach-Bliley Act, for sure. And then, one you didn't mention, any U.S.-based publicly traded company is obviously going to be subject to Sarbanes-Oxley. But then again, what I'm going back to my first point was, when it comes to model language, whenever we as legislators are given model language, we need to be very thorough and diligent to not create overlap, to not unnecessarily create exclusion of some items, to not create new definitions or the same definition but a different term, right? I think it's our responsibility as legislators to make sure to eliminate all of this extra white noise that we are looking to put into Minnesota statute, and I'm not convinced that's been done here. Again, I'm not saying it's a dig on you at all, but just more work can be done here to make this more efficient. So the next question I would move down to is on line 3.4, any information or data except age or gender in any form or medium. Okay, so now this relates to my second question I asked, which was the form, if it's physical. So in your earlier definition of cybersecurity event, information system, information security program, and then non-public information, you're citing electronic information, but then down here you're saying any form or medium. And so there's you're in one area you're specifying digital form, but then in another area you're specifying in any form or medium. And here's an example. So my question for you, Madam Speaker and Representative Elkins, on line 3.4, why are you excluding age and gender from information that would be categorized as non-public information?
Representative Elkins, and Representative Elkins, if you can speak directly into the microphone and speak a little louder, a few members are having difficulty hearing you. Representative Elkins.
Thank you, Madam Chair. Thank you, Representative Lucero. I think everything that you're discussing would be covered under HIPAA.
Representative Lucero.
Okay, Madam Speaker, so if everything that I'm discussing, which is directly from this bill, is covered in HIPAA, this I think makes the point I'm trying to make here is a lot of this is redundancy. And I think we need to be more narrow in scope in what we're targeting rather than just throwing out a bunch of new statute that may already be covered. And as we go down the line of questioning here, there is more stuff that I'm not entirely confident isn't already in other areas of Minnesota statute. The HIPAA citation that Representative Elkins just gave would obviously be federal, but that doesn't persuade me to voting green on this. And I would like to vote green. I'm not, again, these are not gotcha, it's just points of clarification. I think that we could probably do better with the model language here. So he didn't answer why is he excluding age and gender in his language. He didn't answer that, but I'll move on to the next one if he would yield for another question.
Representative Elkins.
Yes, is there a question?
I hadn't asked it, I was just wondering if he would yield again.
Oh, there was okay, I'm sorry.
Yes,
there was
of course.
a pause, which I interpreted as the conclusion of the question. Representative Lucero, he will yield. Representative Lucero.
Thank you, Madam Speaker. Thank you, Representative Elkins. So Representative Elkins, as we are aware in the technology or cybersecurity industry, we are trying to protect the CIA triad, confidentiality, integrity, and availability. Those are the goals that we're trying to maintain. And so with that in mind, when I look at line 4.14, I see that you're only interested in two of those, which is security or integrity. And you're leaving off one of them. Again, here's another example where we could clean up the model language a little bit to be more specific to what we're doing. And then on line 4.12, security and confidentiality. Again, so you're making a reference to confidentiality and integrity in different aspects of this. In one spot you say security and confidentiality, and the next line down you say security or integrity, right? So again, more work needs to be done on this language, Madam Speaker. So then when I go down to line 4.29, so this is in the topic of risk assessments. I see assess the sufficiency of policies, procedures, information systems, and it goes on. But I'll draw specific attention to policies and procedures. Well, Madam Speaker and Representative Elkins, we know in the cybersecurity industry that the four documents that we are tasked with either creating or enforcing are the following: policies, standards, procedures, or guidelines. And in your particular language here, you're only referencing policies and procedures. And so you're missing standards, which would be the biggie. Standards would absolutely be something that would be involved in any risk assessment evaluation. So my next question is, Madam Speaker, why is Representative Elkins, which he already said to be yield, why is he not interested in evaluating the standards by which an information security program is built as part of a third party or other risk assessment?
Representative Elkins.
Thank you, Madam Chair. Representative Lucero. Representative Lucero, this bill, as I read through it, this is an agency bill, comes to me through Commerce, but as I read through it, what I saw is basically a best hits of data security language drawn from a wide range of related acts, including HIPAA, Grahams-Leach-Bliley. Those would be the main ones. And you cannot, when you're doing that, when you're regulating for an industry across multiple vertical lines, it's impossible to completely conform with any of the language that is in the particular bill, the federal bill that governs that vertical line. There are differences between HIPAA and Grahams-Leach-Bliley. Sometimes they're very subtle, but when the people who put this model ordinance together did so, they did their very best to try and acknowledge those differences in the overarching federal statutes that this bill also has to conform with. And I think they did a pretty good job. This bill has been thoroughly vetted by all of the health plan, the health insurance companies, the financial insurance companies, the property and casualty companies. None of them, nor any of the data privacy advocacy organizations, have expressed these kinds of concerns as the bill has gone through the committee process.
Representative Lucero.
Well, thank you, Madam Speaker, and Representative Elkins. There's a lot of stuff that doesn't get addressed or have concerns expressed by all kinds of advocacy groups, but we as legislators, we find details that are overlooked by a multitude of committees. One of the greatest people that I think can nitpick, I don't mean this in a derogatory way, no, it's a positive way. One who has an eye for extreme detail is Representative O'Neill. And she is one who can find wording, because words matter, that have been overlooked by a multitude of organizations, lobbying groups, or committees, right? So just the fact that nobody else has expressed concern, and I'm the first one who's pointing out glaring holes in your language, doesn't make it any less a concern. So I hope that wasn't where you're going. But Madam Speaker, would he yield for my next question?
He will yield. Representative Lucero.
Thank you, Madam Speaker. So, Madam Speaker and Representative Elkins, you just cited a bunch of industries. Those that are subject to HIPAA, those that are subject to high-tech, and a bunch of others in the list that you just produced. Every single one of those industries, in order to implement security controls, we develop, those of us professionals in the industry, we produce policies, standards, and procedures. It doesn't matter what industry you're in. Those documents are agnostic to the industry. They are agnostic to the technology controls in place to protect information, whatever form it's in, digital or physical. And I've already pointed out how you have glaring holes in the information being physical. I could take, you make a reference to 250 names being the threshold. Well, if somebody prints out 251 names that include their address, social security number, and date of birth, and they leave it on the copier, or they leave it on their desk unsecured, and the cleaning crew comes in and takes that, that's a data breach. But it was a physical copy, not a digital copy. That's why I asked you the question, why are you only having digital in scope? Because I was trained as a security professional in the medical industry, the medical insurer, which I worked, that a printout is and left in an unsecured area is just as damaging to those whose data is compromised, because that can be taken and then used and abused. Okay, so then I'm now to this point on line 4.29. In fact, I would draw members' attention, if you still have it, I still have the previous bill that we just looked at and passed. This would be HF1913, the one I voted against. If we look at line 4.4 and 4.5, we would see that there's a reference, it's existing language, existing statute makes reference to standards and policies. So clearly standards are important. So my question for Representative Elkins, the fact that standards are agnostic and the fact that you want to perform a risk assessment, how can you possibly perform a sufficient risk assessment without examining the standards documents?
Representative Elkins.
Thank you, Madam Chair. Thank you, Representative Lucero. You know, the bill, as well as the related federal statutes, Graham's, Leach, Bliley, and HIPAA primarily, do require that a company governed by this develop those kinds of standards. But, you know, Representative Lucero, these are all questions that you could have asked me in the Commerce Committee, and which would have been a much more appropriate place to ask those questions, because we could have actually taken steps to address them. But I've also worked for insurance companies in healthcare and in financial services, and I have taken both HIPAA training and Graham's, Leach, Bliley training several times. There are significant differences among them. Otherwise, I wouldn't have to go through, in some cases, both a Graham's, Leach, Bliley class and a HIPAA class in the same year. So I'll leave it at that, Madam Speaker.
Representative Lucero.
Thank you, Madam Speaker. Well, Representative Elkins, let's talk about the Commerce Committee. I was shut down on the Commerce Committee numerous times. Not only myself, other Republican members. We were shut down, cut off, limited debate, and told to essentially shut your mouth. Okay, that was the experience on the Commerce Committee. And so when I tried to ask you questions, Madam Speaker and Representative Elkins, if you would remember, the chair of the Commerce Committee, he said, let me remind members of the committee, we're being very narrow in scope. All right, so Representative Elkins, Madam Speaker, Representative Elkins, I made an attempt to discuss other concerns I had with this bill, but I was shut down by the Democrat leadership, which again was the process that we've had to endure, being the recipients as the Republicans this entire time in the session so far. But again, you're not, Madam Speaker, Representative Elkins is not answering the questions. Standards, you know, yes, you keep referencing HIPAA and high-tech, but look at your own bill. It's subdivision 3, beginning on line 4.19. You're talking about risk assessments. Risk assessments. So you are requiring a risk assessment be performed. It doesn't matter that there's additional regulatory compliance mandates from federal or state requirements. You are requiring a risk assessment be performed. And as part of that risk assessment that you want performed, you are missing standards. Look at it right there. It says policies and procedures. You're missing the standards documents, which are, they are incredibly important for any information security program. So you continue to cite these additional regulations as a way, I think, to distract, and I'm not trying to, these are not gotcha, it's just, I don't think this language is ready for prime time, and I would hate for it to pass in this form. I won't ask to yield anymore, I'll just point out some of the other glaring holes. Let's see. When I look at line 9, beginning on line 9.1, which is section 4, you make a reference to a criminal investigation. Actually, that's line 11.2. So drawing your attention to 11.2, are there any requirements that, I guess this is rhetorical at this point, there's nothing in here. You are saying that the commissioner can share this information or share with other parties, but you have no requirement that there's a protection around it. So you're empowering the commissioner to share information without the requirement to protect it. And how would it be protected? Is it existing systems? You want information shared up to the commissioner and their department, but is it going to be stored in existing systems? What are the controls around it? How are they empowered, and what are they empowered to do around it? Looking at line 13.10, the Commissioner of Commerce and Commissioner of Health may take action that is necessary or appropriate. I hate the word appropriate in statute. What does that mean? What exact action are you empowering these commissioners over our private industry? You're empowering them to take action that's appropriate. What does that mean? Be specific. You can be specific. You should be specific. when you look at 11.3, the commissioner actually started 11.2. The notification may be delayed to a certain date if the commissioner determines that provided the notice impedes a criminal investigation. Does the commissioner have the authority to supersede other state statutes in this regard? So if there are other state statutes that might be in scope or in play with what you've termed as a cybersecurity event, and they have their own notification requirements, does this proposal that you have that begins on line 11.2 through 11.3, that the commissioner can delay the notification? Well, what happens to the other parts in statute that might be in scope? Does this prevail, or does the other prevail, or does it create a conflict that we now need to send to the courts to resolve, right? And this is a great example where we should be clarifying and making certain that we understand exactly what to do in this. When I look at, here's a glaring hole. So when I look at 9.18, you make a reference, any consumer residing in this state. Well, compare that to your definition of consumer. Consumer means any individual, et cetera, who is a resident of the state. Well, being a legal resident of the state, and then as you term it here on line 9.18, residing in the state, that those are two different things as far as I understand. Being a resident of the state is having an address, a permanent address, having, obviously, it's where you vote, and having identification as such. But residing in the state, I could be a snowbird and I might be residing here, but this is not my residency. I might live here for 5 months out of the year. Well, am I in scope or am I not in scope? Because according to your definition, you're saying that who is a resident. Here you have conflicting language now saying somebody is simply residing. But then earlier in that same paragraph on line 9.7, you make references to this state is the licensee state of domicile. In the case of an insurer, the licensee's home state in the case of a producer, and then you have a comma, and then it says, as those terms are defined in Chapter 60K. Well, I looked up Chapter 60K. I wanted to know exactly how are these terms defined? What is the definition of state of domicile, the legal definition, if we're going to make a cross-reference? The definition to licensee's home state, a producer, right? Because producer is not even in your list of definitions. So what is the definition of these things, including producer? Well, lo and behold, I looked up 60K, Madam Speaker, and I don't see any of these definitions, right? I went to the definition of terms in 60K, and I don't see these things. So we're making a cross-reference, and I'm not exactly sure. 60K is a large chapter. As members know, I mean, that's the top level, 60K. We can be more specific. We can be refined. We have the option to do this right. And again, members of the committee, such as myself, were just shut down when we tried to highlight these aspects. Then we have, it just goes on and on. I've got so much here. I mean, look, this is just one page of stuff. And we can and should do better. And Madam Speaker, you know, I can keep going on and on. I probably should, to highlight how this is not ready for prime time. So Madam Speaker, I guess at this point what I would do is I don't want to kill the bill. I think we can move it forward. I think we can do so after we've cleaned up this language, tightened it up, made sure there aren't conflicts in these different definitions, conflicts with the existing statute. So Madam Speaker, at this point, I would actually make a motion to lay this bill on the table.
Representative Lucero makes the non-debatable motion to lay the bill on the table. Hold on just 1 second. Seeing no permissible discussion, all those in favor of the Lucero motion, please say aye.
Aye.
Those opposed, please say no. The motion does not prevail. The bill is before us. Any further discussion to the bill?
I will finish it up, Madam Speaker.
Representative Lucero.
Thank you, Madam Speaker. I just love these roll call votes over Zoom completely. not roll call, voice votes over Zoom, completely meaningless. But I appreciate, Madam Speaker, your ability to listen with a keen ear, trying to discern the yeas from the nays over Zoom. But members, again, it's not my intent to be gotcha. It's not my intent to kill this bill. I think there is a great opportunity to move forward. But one of the things that I learned, I think it was from Representative Erickson. It's been a number of years now, but it was when I was a first-term member. And one of the objectives that was impressed upon me, and I'm giving kudos to Representative Erickson, and she may or may not have been the one who told me, but somebody in my first term gave me the good advice of, Eric, we don't need to pad state statute. The objective should be to minimize state statute, not have redundancy, not have duplicative definitions, where possible to cross-reference, use existing statute, because that is the cleanest and most efficient form of law in the state of Minnesota. That is the antithesis of what's happening here. This is padding state statute. It is inefficient. There's duplication. There's conflicts, I think, within the very own bill, as I pointed out, just a few examples. Members, I would highly encourage a no vote at this time, allowing Representative Elkins to further refine the language. Thank you.
Was that a question, Representative Lucero? That was a conclusion.
It was a conclusion. Thank you, Madam Speaker.
Representative Elkins.
Thank you, Madam Chair. Just, in conclusion, I would say that this model ordinance has to be passed if Minnesota-based insurance companies are going to be able to retain their ability to do business in other states without having to go through the individual certification processes in each of those states. The purpose of having these uniform acts that extend across states is that it's a reciprocal agreement, and under this reciprocal agreement, we honor the certificates that have been issued by the home states of other insurance companies, and they do the same for us. The U.S. Department of Treasury has strongly urged states to adopt this bill. Already 8 of them already have. We would be the 9th, and it needs to pass this year. So members, this is a necessary bill. I would urge you to vote green.
Seeing no further discussion, the clerk will take the roll on the bill. Members, please vote. Will the clerk please call the names of those who have not voted yet?
Baker.
Baker, no.
Baker, no. Berg.
Berg, yes.
Berg, aye. Davids.
Davids votes aye.
Davids, aye. Fisher.
Fisher, aye.
Fisher, aye. Franzen.
Franzen, no.
Franzen, no. Gomez.
Gomez, aye.
Gomez, aye. Grassel.
Grassel, no.
Grassel, no. Gruenhagen.
Gruenhagen, no.
Gruenhagen, no. Hamilton.
Hamilton, no.
Hamilton, no. Hanson, R.
Hanson, R, aye.
Hanson, R, aye. Hausman.
Hausman, aye.
Hausman, aye. Heinrich.
Heinrich, no.
Heinrich, no. Hewitt. Hewitt, aye. Listlegard.
Listlegard, aye.
Listlegard, aye. Mariani. Mariani. Marquardt.
Markwart, aye.
Marquardt, aye. Mason.
Mason, aye.
Mason, aye. McDonald.
McDonald, nay.
McDonald, no. Nash.
Nash, no.
Nash, no. Nelson, N.
Nelson N, no.
Nelson, N, no. Pinto.
Pinto, aye.
Pinto, aye. Pryor.
Pryor, aye.
Pryor, aye. Ryer.
Ryer, aye.
Ryer, aye. Thompson.
Aye.
Thompson, aye. Erdahl.
Erdahl, aye.
Erdahl, aye. Wolgamott. Wolgamott, aye. Mariani. Mariani.
The clerk will close the roll. There being 82 ayes and 49 nays, the bill is passed as amended and its title agreed to.